So I'm going to deny that request based on that. Then we have the motion to require hearings and allow follow-up objections to any statement made by plaintiff or his attorneys. And that one was filed on February 10th, which I have here, and I think this was one of those that you had responded to simply in the letter of the 27th. Mr. Dyke, any additional argument on that motion?
Well, it's often hard to hear and process everything that's said here, so it's a challenge to try to address everything that needs to be addressed during these meetings.
Anything else? Ms. McLeod?
No, Your Honor.
Okay. So I'm going to deny this motion. I'm honestly not certain what it's requesting. I don't see any basis in Oregon law for the request. We hold the hearing occurs, parties make their arguments. If it's an evidentiary hearing, they present evidence. I make a ruling, whether it's at that hearing or at some point later when I've taken it under advisement. The Oregon revised statutes, the Oregon rules of civil procedure, the uniform trial court rules of evidence, and any other rule that might be applicable to the hearing or a trial are going to be applied to both sides, applied the same. That's the way it's supposed to happen. Case law is really clear. That's the way it's supposed to happen, whether you're represented by an attorney or not. So that's how I intend to apply them. I'm going to deny the motion just because, as I said, I think I'm obligated to provide everybody an equal and fair hearing. And I don't want to make it appear that by denying that motion, I'm attempting to deny that right. I intend to give everybody that right and opportunity, but this motion simply isn't proper under the law. Mr. Dyke, you had something?
Our concern is if we, by virtue of some technicality, we fail to object to something, and all of a sudden our right to a trial by jury is somehow derailed. We feel that's Oregon Constitution right, and we're really of a little technicality preventing that from happening. If we desire that, I believe we're entitled to that.
Assuming that a jury trial was requested in your answer,
correct,
I believe you would be entitled to one on the ejectment and the trespass claims, so that's claims 2 and 3. Claim 1 for adverse possession or quiet title, there's not a jury trial right to that claim, so it would be a bifurcated trial in terms of that. And at this point, I understand you're concerned about some failure to object. I can't preemptively protect you from some procedural process that might have some impact on your rights. At this point, I'm not sure what that would be that would somehow eliminate your right to a jury trial on those two claims. But for example, if they had filed a request for admissions and you failed to respond in an appropriate time, I can't in advance say you're going to get extra time on these things. That would be something we'd need to address at the time, take up, so that would be when that's appropriate to deal with. All right, let's move on to the next motion, which is the motion for immediate criminal prosecution of Ms. McLeod and her firm for aggravated perjury. That one was filed February 11th, I believe. Yes. And I believe, Ms. McLeod, that was one addressed by your letter response as well.
Yes, Your Honor.
Mr. Drake, anything else on that motion?
She says a courtesy copy is mailed. We are not aware of that. We only was served 2 copies by the third-party service service.
Of the amended complaint?
Yes. That is the main focus of our motion. It's our contention, as the facts show, that Ms. McLeod is intentionally or otherwise misstating information in an attempt to influence the court and us. And we feel it's not proper.
Your Honor, can I respond just very briefly? I mean, I think that this particular motion itself, we had a discussion at the last status conference about what's within the court's ability to grant, so this may be outside, but neither here nor there. We have a proof of service that we mailed the amended complaint to the estate. We have always stuck by that and said that that's what we did. And then, as we are required to do, a process service company came and served Mr. and Mrs. Dyke personally on the amended complaint when it was filed against them, because it was the first complaint that had been filed against them. It's no more complicated than that.
Objection.
And all of those are part of the court record.
Only served document is not a courtesy copy in the mail. We received no courtesy copy in the mail as contended.
Okay, and that's your argument.
Well, furthermore, if you look at her statement right there, when I filed the amended complaint, and so forth, at that same time, the default order against the estate had not been entered. If you turn the page, you can see the official court summary that shows when the order was signed, when it was entered, and when the amended complaint was submitted. And the amended complaint, according to the court record, was after the default order was signed, contrary to one statement under perjury, under penalty.
Anything else? Anything else, Ms. McLeod, on that motion?
No, Your Honor.
Okay. So, a couple of issues with this particular motion. First, I can't compel the state to file a criminal charge, even if I thought it was appropriate. That's something the district attorney's got to decide to do, go through their process, and I don't have the ability to order that. Simply don't. So I couldn't grant the relief that you're seeking, even if it was clear on the face of your motion that it was appropriate and warranted. I don't know that there is a charge of aggravated perjury in Oregon. At least if there is, I can't recall it off the top of my head. But let's just assume we're talking about perjury. The other thing I would note, Mr. Dyke, is that the order was signed and the amended complaint were both done on the same day, and I recognize that there are times there. Those documents may not always be visible in the system to folks looking at them on the times that are reflected. The order, it may very well be that that time listed is when I signed it, but it can sit in my queue signed for some period of time. It then gets forwarded to the next staff member that needs to deal with it, and then to the next staff member that needs to deal with it, and then eventually is visible on the case. So at this point, I can't say that even what's argued as perjury is inaccurate, let alone whether it's perjury, but whether it was inaccurate or accurate based on what you provided here today.
We signed the order and it was entered at 8:50. I've tested this system for filing documents, and they usually show up within 10 minutes.
Depends on the day. In any event, I'm going to deny the motion. I couldn't grant the relief that's sought, even if I wanted to.
Can you declare this matter to be material to the case?
No, it's not.
So,
a difference
no
of...
penalty for this carelessness.
Well, let me just lay this out. Let's assume that in fact the default order had been entered and Ms. McLeod knew that, filed the complaint or amended complaint after, and then said it happened in the reverse order. That has zero impact on the outcome of the case. It's not an element of the case. It doesn't have any impact on the element of the case. It might be a whole separate issue, but it's clearly not material to the case. True or false, it's not going to have any difference or any impact on what a judgment ultimately says in this case.
I talked to the district attorney, and he didn't know if it was material, so he was not knowing if it was material,
And that's a decision that he would have to make to determine whether or not he goes forward charging. I don't believe it's material based on what I've seen here today, for the reason that even if it was perjury, even if, as you've alleged, is exactly how it occurred, that somehow it was done with this evil intent to mislead the court about what was filed when, it's going to have no impact on the ultimate judgment that determines whether or not this quiet title action is successful, whether or not the ejectment and trespass is successful, and whether or not there's any damages. It's not going to have any impact on that at all. It wouldn't be an issue that would get before a jury. It wouldn't be an issue that would get before a finder of fact when dealing with the issues in this case. Might be some other issue. Might be somehow otherwise an issue, but it's not for the final determination of this case, so it's clearly not relevant or not material. Okay, let's move on then to the motion to prove representation. It looks like was filed on the 12th. Any additional argument on that one, Mr. Dyke?
This dispute is over 1 year old. This all began March 7th of last year. We've yet to truly face our adversary in this matter, and we have reason to doubt whether he is consenting to this in writing, and we'd like to verify that for our own due diligence.
Ms. McLeod, any response to this motion?
We did not submit a formal response. We did it by letter. I think the two additional comments that I would make is that Mr. Dyke has repeatedly asked us to share with him communications that we've had with our insured, and I've told him we can't do that under the attorney-client privilege. Additionally, by our signature on the pleadings, we are representing to the court that we represent.
So you can hold your objections. Go ahead, Ms. McLeod.
That's all I was going to say is that, under the ORCPs, our certification is that we represent Mr. Byers as his attorney. That's how we sign all the pleadings. We state in the beginning of every motion, every pleading that we file on his behalf.
Objection.
Thank you. You had some additional comments, Mr. Dyke?
Yes, they've already shown their carelessness with the inclusion of Terry Byers, and they have a track record of not being careful. So I don't believe this is violation of client-attorney privilege to simply seek and verify that this individual is being represented with his written consent.
Do you have any legal authority that supports your right to force an attorney to provide this information?
Nothing other than common law.
I don't think that provides you that authority, so I'm going to deny that motion.
So if the day comes that we might want to litigate for abuse of process and what's the other one, malicious prosecution, we file a complaint against him, he might say, I didn't approve of that. And that puts us in a very awkward position. It comes where we want to counter litigate against him, and he says, I didn't sign anything. That was the title company. We only know the title company is being driving this for this.
I still don't think you're entitled to that. So then let's see, the next one on my list is